Right. Good afternoon, everyone, and thank you for joining the AAJLJ today. My name is Alyssa Gresh, and I serve as the Director of Programming. And the AAJLJ is the only national Jewish bar association advocating at the intersection of law, human rights, and Jewish values. You can learn more about our work at aajlj.org. We're honored to host today's program on Fuld v. PLO, a landmark Supreme Court decision and a huge victory for American victims of terrorism. Just a few weeks ago, the Supreme Court issued a unanimous ruling upholding the constitutionality of the Promoting Security and Justice for Victims of Terrorism Act, the PSJVTA. The decision affirms that foreign actors such as the PLO and the Palestinian Authority can be held accountable in U.S. courts when they incentivize terrorist acts that harm and kill Americans, and reinforces Congress's power to open the U.S. courts to victims in cases that implicate our national security and foreign policy. The AAJLJ was extremely proud to sign on to the amicus brief in support of the petitioners, joining a coalition of organizations urging the court to uphold the statute. The brief, which was our counsel, Mark Pinkert authored, focused on how the PLO and the Palestinian authorities pay for slave program systematically incentivizes violence, and why we had every right to act in response. This case reflects the AAJLJ's enduring commitment to justice, accountability, and the rule of law. We are honored today to be joined by three attorneys who were involved in this case. So we have Kent Yalowitz. He's a partner at Arnold & Porter and was lead trial counsel for the plaintiffs. Kent previously secured a $655 million verdict. That's correct, right? Under the
55.5, but
under the Anti-Terrorism Act, the largest personal injury award in the Southern District of New York's history. He has decades of experience trying complex, high-stakes cases. Alon Kedem, also a partner at Arnold & Porter, is a leading appellate litigator who has argued 13 cases before the U.S. Supreme Court. He served in the Office of Solicitor General, and he is clerked for both Justice Anthony Kennedy and Justice Elena Kagan. And Mark Pinkert, the AAJLJ's amicus counsel, as a litigation appellate partner at Holtzman Vogel, who represented the AAJLJ and the amici coalition before the Supreme Court. Mark is a Yale Law graduate and former federal clerk whose practice spans constitutional law, complex litigation, and civil rights. I'm also very pleased to be co-moderating today's discussion with Arthur Traldi, chair of AAJLJ's amicus committee. Arthur, he's a very hard person to find online, but he is the senior consultant at Lexpat Global Services. He was a senior fellow at American University's program on technology, law, and security, senior counsel at the Louis D. Brandeis Center for Human Rights Under Law. And earlier in his career, he was a prosecutor at the International Criminal Tribunal for the former Yugoslavia and in chambers at the International Criminal Tribunal for Rwanda. We are very lucky to have Arthur lead AAJLJ's amicus efforts. So we're grateful to all of our speakers again, to all of you, our members, and hopefully future members for being here, and very proud that the AAJLJ played a role in supporting this significant case. With that, I'm going to turn it over to Arthur to introduce our panelists further.
Great, thanks, Alyssa. And just to be clear, I'm co-moderating, Alyssa is moderating, if that distinction makes sense to everybody. But I'll be playing a small role here. And I'm really excited to be part of it and proud AAJLJ was part of the case. Alyssa herself are also members of our amicus committee and played a critical role in this and our other amicus work. So with that, maybe I'll just get us started diving in. Can you tell us a little bit more about the case?
Sure. So the Supreme Court case actually arose out of two separate cases. The lead case was Fuld against PLO. The family of Ari Fuld brought a lawsuit. Ari was grew up in New York. He made Aliyah. He lived in I think he lived in Gush Etzion, and he was killed by a terror or knife wielding terrorist who had been incited to his crime by a speech given by Mahmoud Abbas, falsely claiming that Israel was going to take over the Al-Aqsa mosque. And the
No, that's my.
right, that's the Fuld case. So the then that murder took place in 2018, and Sam, who's on the line, and I think there are some other people on the line involved in representing the Fuld family, brought suit in 2020, shortly after the PSJ VTA took effect. The PSJ VTA was inspired primarily by the other case that was in the Supreme Court, which was called Sokolow against the PLO, and the Sokolow family were in Israel in 2021, in January of 2021. No, I'm sorry, January of 2002. Mark Sokolow had been in the World Trade Center bombing. He had a daughter who was studying in Israel, and the family went to visit her in January after Mark escaped the bombing, they were shopping on the last day of their visit. They were in a shoe store, and a creepy woman was following them around. They left the shoe store. The woman kind of went up in the midst of the four of them, and detonated herself with a backpack filled with explosives that she had gotten from the Palestinian Authority's intelligence division. The evidence of PLO involvement was quite deep in the Sokolow case, and in similar attacks. There were seven attacks in total in the Sokolow case, and in attack after attack, there were terror cells populated by Palestinian Authority police officers, Palestinian Authority intelligence officers, Palestinian Authority security personnel. Very extensive evidence of an atmosphere of violence. This was all during the Second Intifada, or as the terrorists called it, the Al-Aqsa Intifada. The evidence that we brought to trial included convictions of a number of terrorists, payroll records showing that after their convictions, the terrorists were rewarded with pay and promotions by the Palestinian Authority and the PLO. Intelligence records from the Palestinian Intelligence Service complimenting these people, records from the prisoner authority approving their payments because they engaged in these attacks against civilians. The words of the bureaucratic records were as part of his fight for his country. There were martyr files, people who killed themselves as suicide terrorists, who were commended as Al-Aqsa martyrs. The evidence was really extraordinarily overwhelming. And the trial was a lengthy trial. It was a very hard fought trial, 7-week trial, defended by very able counsel, trial counsel for the PA and the PLO. And at the end of the trial, the jury came back with a very significant verdict, which was commensurate with the very heavy loss of life and loss of heavy injuries and losses suffered by the families. The case went up to the Second Circuit, and the Second Circuit decided that there was no personal jurisdiction. The theory of the Second Circuit was sort of breezy. Their idea was the 14th Amendment and the 15th and the Fifth Amendment both have due process clauses. There's all this case law on minimum contacts that are required under the 14th Amendment, so the Fifth Amendment must be the same. And there was sort of a wooden and territorial approach. The terrorists did not commit their actions in the United States. The PA and the PLO didn't engage in any liability creating conduct in the United States, and therefore there was no personal jurisdiction. The result of that decision was quite disappointing. We tried to get the Supreme Court to look at it. They would not. But members of Congress were incensed with the decision. They were very upset, particularly Chuck Grassley and Bob Goodlatte, who happened to be the chairman, respectively, of the Senate and House Judiciary Committees. And they moved legislation very quickly. And we went back to the Second Circuit and asked them to recall their mandate after the legislation was enacted. The legislation was a consent to jurisdiction statute. It said if the defendants took certain actions, that would be deemed to be consent. The panel in the Second Circuit said, oh, too bad for you. The statute is meaningless. It doesn't actually do anything, so you lose. We then petitioned for cert a second time, and while that petition was pending, Congress amended the statute to address the deficiencies that the Second Circuit had identified. The Supreme Court remanded the case for further consideration because of the new statute. And after a very lengthy remand and findings of fact about whether the statute applied, the Second Circuit said, well, you did a good job fixing the statute, Congress. It now works as apparently intended. But unfortunately for you, the statute is unconstitutional. And the reason that they said the statute was unconstitutional is because a consent statute, which this was, consent to personal jurisdiction, has to, under the due process clause, has to either reflect be based on litigation related conduct or a reciprocal bargain. And as you may not remember that rule from law school, and the reason you don't remember that rule from law school is because the Second Circuit made it up. It didn't exist, and they just thought, oh well, this is a good rule to get the result we wanted. So that was the rule that they picked. By this time, the United States government had come into the case to defend the constitutionality of the statute. We petitioned for cert a little early. This gave the government something of a conundrum because they they kind of either had to petition for cert or explain why they weren't doing that. They also petitioned for cert. The court granted the petition and reversed. So that's the kind of, that's unfortunately the short version of a long story.
Thanks, Kent. I particularly appreciated the reassurance that I wasn't forgetting part of my 1L contracts class there, so thanks for that. Mark, maybe you could talk a little bit about, I'll call it our brief, though of course you were representing a coalition of distinguished organizations that we were part of, but about our brief that you did on our behalf and the rest of the coalitions.
Yeah, absolutely. And just to start at the beginning, Alyssa, you said there are 3 lawyers involved in the case. That I've been on the case. I did maybe 2 months of work on a brief. Kent's been doing this for 20 years. So just make sure we get that distinction. If Kent and Alon are like the Michael Jordan, Scottie Pippen, I was like the water boy involved in this case. Giving them a glass of water on the sideline. But no, you're right. I was really honored and privileged to submit an amicus brief on behalf of a coalition of 17 pro-Jewish, pro-Israel organizations. Unfortunately, we didn't get 18. I would have put a high on the cover of the brief, but we had 17, so we won't let that ruin our fun. But and we were honored to have AAJLJ on board and involved. And Arthur, it was great working with you, and your feedback and comments were incredibly helpful. So we represented these 17 organizations, and our goal was to support Kent and his team, and to support the plaintiffs and other victims of terrorism, and support the constitutionality of the statute. And so, we wanted to do that in a few ways. As an amicus, you don't want to regurgitate or tread the same ground that the parties are already covering in their briefing. So we wanted to explore some of the history, and we wanted to talk about some of the pay for slave program to give the court some additional context. And I think that's important here because as I believe Ken mentioned, the 2019 statute is specifically targeted at the PLO and the PA, and it specifically refers to their pay for slave program as a jurisdictional hook. So we wanted to give some details about the history of those organizations and talk about how the pay for slave program has been institutionalized over time. So what we did was we started with the formation of the PLO in the 1960s. We talked about Yasser Arafat and his leadership, sort of bringing together more guerrilla terrorist, Palestinian terrorist groups. And, rather than engaging in just sort of guerrilla terrorism, I guess you could call it, as a military tactic, what the organization started to do under Arafat's leadership was to use terrorism as a way to garner international attention or notoriety, as it were. And they did that not just by attacking Israel and Israelis in Israel, but by committing acts of terrorism internationally in hijackings in planes, hijackings of cruises on international waters. Of course, there's the Munich Olympics. And the goal really was to get sort of international attention. And so we talked about that history. And, we live in an international world where Americans travel and live abroad, and many Jewish Americans travel and live in Israel and get swept up in this violence. So it certainly is something that Congress ought to be and did become interested in to the extent that it affects Americans. We talked a lot about pay for slay, and what we wanted to show the court was that this is not just sort of an ad hoc system of, you commit a terrorist act, we're going to, dish out some cash. Over time, and especially after the Second Intifada, the pay for slay program became institutionalized through law, through bureaucracy. The PA actually passed laws that created a bureaucracy that would manage money coming in, and that it would sort of pay it out to terrorists and their families according to a certain schedule and under certain standards. And we wanted to make that point. We thought it was important because insofar as Congress had this foreign policy goal of deterring terrorism by going after the money through civil judgments, showing that this is a real well-funded, well-oiled machine, we thought was important. We also wanted to highlight the sort of cultural aspects of pay for slay, how the PLO and PA honor who they, what they call martyrs, just terrorists, but they, name streets and landmarks after them. They have a Martyrs Day. And so we wanted to, give that additional context to the court. I think Kent and Alon and his team, they did an amazing job, but they just don't have there's a page limit. They don't have the space to get into, every single historical detail. So we wanted to expand on that. One of our other goals was to talk about some of the specific victims, over the decades, American victims, to give them a voice, to identify them by name, to tell a little bit of their story, and to sort of personalize the case. We didn't want that to get lost in the sort of legal dispute, and as important as it is, these are real stories and real victims, so we wanted to give them a bit of a voice. And then I think the last thing that we wanted to accomplish was we wanted to show that the statute was a reasonable exercise of congressional power because of the sophistication of the PLO and PA and their sort of intentional targeting of Americans, not only in sort of, for example, Leon Klinghoffer, they intentionally killed him in 1985 because he was American, but targeting American media, social media, setting up offices. And we wanted to show that they had a real operation in the States and that they could sort of fairly be expected to get pulled into federal courts. So those are really the four goals. And we hope that it was ultimately helpful. The court did find that the exercise of jurisdiction was reasonable, although it didn't hold that that was the standard. But assuming that there's a reasonable standard, it said clearly this is a reasonable exercise of jurisdiction. And I think that's, of course, 99% attributable to Kent and his team. Hopefully we offered a 1%, or icing on top to help get the court to that position. So it was a real honor again to work with AAJLJ, and it was great to work with you, Arthur. So thank you for that.
Thanks, Mark, and thanks to you and to the rest of your team for your work. So I think, Alon, we've heard a little bit about the outcome of the case already, but if you could give us a dive on the significance of the opinion and how the court came out here, I think that'd be really helpful for framing the rest of our conversation.
Sure. And I should say at the outset, despite my background and the fact that Kent and I are from Arnold and Porter, we're not here in that capacity. We're just here speaking in our own personal capacities. So the Supreme Court took on a couple of questions. The most basic question is whether the standard for personal jurisdiction under the Fifth Amendment's Due Process Clause, which applies to the federal government, is the same as the standard that applies under the 14th Amendment to states' exercise of personal jurisdiction. And as alluded to earlier, the Second Circuit said that they were the same standard. It's the same, same wording generally for the clauses, but the Supreme Court disagreed. What the court explained is that personal due process in the context of personal jurisdiction serves two overarching functions. One is that it serves to protect against unreasonable and unfair exercises of government power. And here the court had in mind trying to hail someone in court very far away from where relevant offense happened, in a distant forum that might be inconvenient for them or where they would struggle to mount a fair defense. And then the other purpose is to serve interests of federalism. It's to ensure that one state does not improperly try and reach out and exercise power over events that really are of greater concern in another state. So just to take a very basic intuitive example, if you get into a car accident in Georgia where everyone involved is a Georgia resident, the suit should be maintained in Georgia, not in New Jersey. And if New Jersey were to allow a suit there and exercise power over that dispute, there would be something a little bit problematic about that. And based on that latter consideration, which the Supreme Court has in a number of cases emphasized the importance of, the Supreme Court said, therefore, the standards are not the same. And that was a very fundamental and key point that told you just right off the bat that the court was not going to agree with the Second Circuit. Then the court had to sort of explore the follow-on question, well, if the standard is not the same, what happens next? How do we evaluate federal statutes under the Fifth Amendment? And the court didn't try to provide a comprehensive answer to that, and instead just said, based on the circumstances and facts of this case, we think that Congress's legislation, the PSJ-VTA, is a reasonable and appropriate exercise of power that comports with the Fifth Amendment's due process clause. And it reached that conclusion for a number of reasons. First of all, the statute is limited to one specific type of claim. It only applies to claims under the Anti-Terrorism Act. It also is limited to one specific type of defendant, the Palestinian Authority and the PLO. And more than that, it only applies to cases that involve terrorist attacks against Americans abroad, which is a subject of paramount concern to the federal government and a subject over which the political branches, that is the president and Congress, have great expertise and plenary authority under their powers over international relations and foreign affairs and national security and national defense, among other things. The court also emphasized that there was sort of nothing, that the specific triggering conduct that rendered the PLO and PA subject to jurisdiction under the PSJ-VTA, that both of those also had important connections to the United States. So if you recall, one of the triggers is what we've been calling the pay for slay policy, which is that if the PLO or PA make payments to terrorists by reason of terrorist attacks that they committed against Americans, that is one trigger. And obviously, for the reasons that Mark just articulated, that is a subject of serious concern to the United States, serious and appropriate concern, and something that the United States has a strong interest in disincentivizing. And the other trigger is whether the PLO and PA are present within the United States and engage in essentially any conduct that's not strictly related to their UN activities. So if they're present here and engage in lobbying or, public relations or other activities, then that also is sufficient to trigger the consent to jurisdiction provision. And because of those close connections, the Supreme Court said that Congress could have just said, for that reason, the PLO and PA are subject to jurisdiction. And therefore, the Supreme Court sort of sidestepped the question about consent and said, we don't really need to decide whether this is a valid approximation of consent because the Congress could have just imposed these conditions directly. And that's all it really said that it needed to decide in order to know that the statute was permissible. It also did a sort of brief analysis pointing out that there was nothing fundamentally unfair about requiring the PLO and PA, which are present in the United States and very sophisticated entities and can defend themselves, with all the money that they have. There was nothing fundamentally unfair about making them stand trial in the United States. So that was a decision on behalf of 7 of the justices. 2 other justices, Justice Thomas, joined in part by Justice Gorsuch, would have ruled for us on even broader rationales. Justice Thomas would have found that the PLO and PA probably don't have due process rights in the first place, and so actually can't contest personal jurisdiction. And then joined by Justice Gorsuch, he would have essentially said that Congress has more or less plenary authority to prescribe jurisdiction in federal courts, at least in cases involving federal cases. So it was a unanimous decision that was unanimous in the judgment upholding the PSJ-VTA. And important for us, and we can get into this in a moment, the Supreme Court did not merely vacate the decision below, it said it reversed the decision below. It's a bit of a technical distinction, but in general, vacate means we are throwing out the decision below and sending it back for further consideration about whether the decision could be reached on other grounds, whereas reversing means, no, you got it totally wrong. We are throwing out the decision below, and you should do something close to the opposite of what you did.
Great. Thanks, Alon. Alyssa, I'll turn it over to you.
All right, thank you so much for all that really interesting and important background. So I'm going to start with a few questions on my end, and then I will open it up to the attendees. So feel free to write your questions in the chat. So first, so what happens next in these cases? You know, how do you see Fuld playing out? And in Socolow, is the award back in effect? What are the next procedural steps of trying to enforce?
Sure. So in Fuld,
Yeah, Ken, go
Is-
ahead.
in Fuld, I think it's likely to be very uncontroversial that the case needs to go back to the district court. Jurisdiction should be pretty clearly established, and then there was a motion to dismiss, but without, it's not my motion, it was written by other people, but it seemed like they had pretty good defenses, and so I think it's probable that that case will move into discovery, although one never knows how the motion to dismiss is going to go. Isakalo is a bit more complicated. Because of the complicated procedural history, we have to go back to the Second Circuit and ask them to reinstate the district court's judgment. And that's something that'll get briefed over the coming months, weeks and months is my guess. And we'll see from there. There's some at least theoretical possibility that the Second Circuit would require a retrial, but that would be an extraordinarily burdensome and unnecessary step. But we'll see.
Okay, and what are the implications of the Fuld opinion, do you think, for future anti-terrorism cases?
So I'm happy to sort of take a stab at that. Again, just speaking in a personal capacity, I think that there needs to be further decisions in the lower courts, by which I mean everything below the Supreme Court, trying to figure out what the Supreme Court's decision means for federal statutes like the Anti-Terrorism Act, among other federal statutes, um, and how to figure out whether those statutes allow federal courts to exercise jurisdiction over non-U.S. persons and entities. And, I think it's clear that the 14th Amendment standards no longer apply. I think the Supreme Court gave some general indications about the types of considerations that might be relevant, but I think there's going to be a lot of fight over how broadly those can be applied. And so, it may be that individual statutes will be upheld in their entirety. In other cases, it may be that people will have case-specific objections that either will or won't succeed. So there's a lot left on the table, and I think there's room for both sides, both people who want to exercise jurisdiction over foreign persons and entities and those who oppose it, to make their arguments based on this decision.
Yeah, and if I could just add a few things to that, I think, Alon, maybe you're a little bit more charitable in reading the decision. I think it will be kind of confusing because on the one hand, the court pointed to the narrowness of the 2019 jurisdictional statute and how it's specifically applied, which the rest of the Anti-Terrorism Act, the sort of main provision, wouldn't have that sort of specificity. But at the same time, the other ingredients that it pointed to were deference in foreign policy and sort of the reasonableness of or sort of how closely tied the exercise of jurisdiction is to the purpose of combating terrorism. So I could see the decision being interpreted in different ways to reach different results. other than, of course, for the PLO and PA, which now I think, which is clearly resolved. But, if I were a lower court applying it, I would see several ingredients, but not very clear direction.
Right. And do you think the outcome here is limited to the PSJTVA, or could it potentially have implications for the ATA or other statutes?
So I'd definitely say implications, but as Mark said, exactly what those implications mean in particular cases, I think a lot remains to be decided.
And
Okay.
can I add one more, maybe even ask you guys a question here, because I'm curious myself. That what's interesting about one of the things that's interesting about this case is that it's 2025 and the court hasn't really addressed this question. And as it points out, it's because in most personal jurisdiction cases, the district court is applying the state law of the state in which it sits. And this sort of analysis only applies if um, uh, personal jurisdiction is specifically authorized by a federal statute. In your preparation for oral argument, um, or in briefing the case, did you guys find a lot of statutes that specifically authorize jurisdiction? And because I didn't do that sort of analysis, so I'm just curious whether the decision will even go beyond anti-terrorism into other personal jurisdiction statutes.
So I could talk about that a little bit. I'll associate myself with Alon's comments that that or caveat that what I'm going to say doesn't reflect the views of other lawyers in my firm or certainly our clients, and depending on what cases I might work on in the future, these might not even be my views in the future. But I would say the the cases will probably break into three buckets. There are certain statutes and authorities where the federal government has certain civil enforcement powers. Enforcement powers under IEPA, which is like allows for sanctions or export controls, civil forfeiture, civil penalties for violating various federal statutes that have an obvious extraterritorial effect, like narco terrorism, material support, where the federal government's enforcement interests are very high, and people who are subject to enforcement activities are quite reluctant to challenge uh, jurisdiction or authority anyway. And I think those cases are very unlikely to be challenged. Those powers are unlikely to be challenged. And if they are challenged, I think they're very likely to be upheld because of the way that the Supreme Court articulated the test in Fuld, which has to do with the interests of the forum, the interests of the defendant, and the interests of the plaintiff in vindicating its rights. There's a second group of cases that I think are going to this is going to be where the sort of debate that Alon and Mark were talking about will most obviously occur. There are a lot of statutes like the Sherman Act or the RICO or the Securities Act, the Exchange Act, the Commodities Futures Trading Act, statutes where Congress has authorized service of process. So they're like the ATA, and they're cases where they're statutes where many cases have been dismissed in the past under the strength of holdings that that the 14th Amendment the Fifth Amendment standards were the same. And so if people fixed prices in London and didn't engage in activities in the United States as a result of that, or as part of that conspiracy, they were being dismissed. And that will be an area where I think there's likely to be arguments on both sides of what are the interests of the plaintiff, what are the interests of the forum, what are the interests of the defendant, and I think there is at least there seems to be a room for some solicitousness for the small time defendant, the small business, somebody as to whom there would genuinely be difficulty in litigating in the United States. That does seem to have caught on the attention of a number of justices. And then the third bucket are statutes where there is no service of process statute, and the law is obviously extraterritorial. Things like the Torture Victim Protection Act or the Alien Tort Statute. And there, that's just a big mystery to me how those will come out. And there's a federal rule of civil procedure called Rule 4K2. It's very unclear. That allows personal jurisdiction to the limits of the Constitution. It's not really clear that statute or that rule comports with the Rules Enabling Act, or if it does, there might have to be some limits on it. So that's just sort of I think unmapped. So where I think we'll see the cases breaking.
Thank you. And so what do you think are the practical implications? And I know this is hard to guess, but regarding deterring the PLO and the PA, or terrorist groups generally.
I think this is likely to solidify the ability of plaintiffs to hold not just the PA and PLO accountable, but others who have engaged in terrorism or who have provided material support. I mean, we'll see. There are arguments on the other side, but I think once you strip out the territorial aspect that was constraining personal jurisdiction, and you go to an interest analysis, the anti-terror interest is very strong. The interest of victims for justice is very strong.
I'd like to also point out that during the course of our briefing in the Supreme Court, the PLO and PA announced that they were ending their pay-for-slay policy. Now, I think there are significant reasons to doubt whether that's correct. But just the fact that they announced it and tried to rely on that fact during the course of our briefing, I think suggests that the PSJVTA puts at least some amount of pressure on them in that direction.
Yeah, and I'll just add one point connecting it back to the amicus brief that we worked on. As I discussed earlier, the system is very much built on the flow of money. Obviously there's a cultural aspect and an ideology that is incentivizing people and bringing them into terrorism. But a lot of people in Judea and Samaria or in Gaza are living in poor conditions because the governing authorities are not using the foreign aid that they're getting to improve their lives. They're using it for terror tunnels or to support terrorism. And so If you don't have many opportunities, and then suddenly you have an opportunity to make a lot of money for you and your family, that might draw you into terrorism. So I think the hope is, depending on the success of these sorts of lawsuits, that it could significantly interrupt that program and that broader structure. I think one way to look at what Congress was trying to accomplish is to not only to bring justice to the victims and try to make them as whole as possible, but to sort of use them as private attorneys general, in a sense, to to uh, to go after money, and in doing so deter, um, uh, and to defeat the system. Congress has implemented other statutes to limit the PLO and PA in supporting terrorism, like the Taylor Force Act, for example, and limiting foreign aid. But bringing in private plaintiffs and hoping that they have success, I think will help bring down this system.
And along those lines, we have two questions in the chat about enforcement of the Sokolow judgment. Asking about whether the PLO or PA has assets in the United States and how it is that the judgment, if we can get it reinstated, might be enforced. And Kent, I think you're the best person to speak to that.
Sure. Well, this is not the first anti-terror case to go to judgment against these defendants. And in the past, plaintiffs who had ATA judgments did find assets in the United States. I believe there are still some assets in the United States that would be subject to attachment and execution. We'll have to see about that. There's also there are flows of funds that the Palestinian Authority and the PLO receive. They're not a state, they're not recognized as a state of the United States or in Western Europe. And so, and certainly not in Israel. And so they have a number of flows of funds. They get foreign assistance, they raise taxes, and they own substantial assets. And so, having a judgment against the PLO and the Palestinian Authority, it's sort of like having a judgment against, I don't know, the city of Houston. Like, they if it's a small judgment, they can pay it right away. If it's a large judgment, they might not be able to pay it in one bite, but they can certainly, they've got a $5 billion a year budget, many hundreds of billions of dollars of which they've announced they're no longer going to spend on paying terrorists. If that's really true, then that'll free up some money and they can use that to pay their just debts.
Alyssa, you're on mute.
Thank you. That's very helpful. We all anticipated questions on enforcement and collection, of course. So we have Rhonda Lees has asked about the role of the State Department in these cases.
So the State Department has a complicated relationship with these cases. Senator Grassley likes to say there's no American desk at the State Department. And the State Department's bureaucratic mission is to have good relationships with people all over the world, perhaps sometimes at the cost of not putting interests of U.S. terror victims first. There is leadership at the State Department right now who have been very solicitous of terror victims in the past, Secretary Rubio has been very involved in supporting terror victims for many years. The legal advisor at the State Department, Reed Rubenstein, has been very involved in litigation that that is focused on holding the PLO and the PA accountable for bad conduct. And so the State Department, we'll see how their views play out. I think right now the leadership of the State Department is likely to be supportive of our work.
Should also point out that the support of the federal government or lack of support has been an important ingredient in this case since long before I got involved. So when the plaintiffs sought Supreme Court review the first time, the Supreme Court asked the federal government for its view on whether the petition for review should be granted, and it recommended against granting review. I should say I was at the Solicitor General's office at the time, which is the office that handles Supreme Court litigation on behalf of the Department of Justice, but I was not involved in the case. And I know from talking to Kent, it was obviously a big disappointment that the government did not support review at that time. One of the important things that Kent and I, worked for and fortunately were able to get was the intervention and support of the United States to defend the constitutionality of the PSJ VTA. So they intervened in the district court and then participated both there and on appeal to the Second Circuit, and then again, petitioned the Supreme Court for review and participated on our side there. It is an open question what role the United States is going to have going forward on remand when we go back to the Second Circuit and ask it to reinstate the jury verdict. We would obviously very much like to have the support of the United States in that.
And another question from Rhonda. What are your, so actually the AAJLJ has been recently focusing on some cases brought on behalf of the victims of October 7th. We recently had Ozen Law discussing Bashar v. Masri and Weiser v. Iran. So what are your thoughts about cases brought on behalf of victims of October 7th and potential implications that your cases will have?
So I haven't seen a lot of impact of the Fuld case on those cases yet. I guess I should preface it by saying, again, my personal opinion, Gary Osen, for those who don't know him, is really the dean of this kind of work. He does really exemplary work. He's an extraordinary lawyer, and he's been doing great work in this space. He and his colleagues. So some of those cases are unlikely to be affected by Fuld. I think they have a case against UNRWA. UNRWA's immunity or non-immunity is not really governed by constitutional doctrine. Similarly, they have, I think, some cases against Iran. And again, Iran is most likely would not. Iran doesn't defend these cases, but at least not at the trial court level. They would not have constitutional due process rights. I think it's fairly clear at this point. So I'm not sure that, there may be cases that where it may, it becomes germane ATA type cases. And my guess is that people who have been representing October 7th families are thinking about that issue right now, and that this may change. Well, one of the things is that the idea that 14th Amendment, sort of territorial restrictions apply was pretty ingrained in the law in the Second Circuit and the DC Circuit, other places where litigation might arise. And so I think there probably have been a lot of cases that might have been brought that weren't brought because of that. And so people might rethink that. Not that it's necessarily an easy path, but I think that we might see more cases brought than would have been brought without Fuld.
There also
you.
may be a more direct connection to, in terms of the PFLP, the Popular Front organization, to the extent that it was involved in October 7th and is sort of a membership organization under the umbrella of the PLO. So maybe the full decision could have more direct implications, but I agree otherwise with everything Ken said.
Thank you so much, guys. Before we close out, I just want to turn it over to Rhonda Lees, one of our VPs.
Yes, I just want to recognize some of our board members and special friends on the call. Arthur Trowdy, Steve Greenwald, he's also a previous Pursuit of Justice Award recipient. Stan Fink, Richard Goldenhirsch, Alan Nesbitt, Alyssa, of course, Akiva Shapiro, also a previous Pursuit of Justice Award recipient, as well as two friends, Joel Margolis, who is AAJLJ's legal correspondent, and Yafat Barak Cheney, who's at the WJC, who, among other things, organized the lawyer solidarity trip that I attended in January of 2024 to Israel. So thank you. Back to Alyssa.
Okay. Thank you, Rhonda. It's always good to recognize our really special board members and collaborators and draw attention to their incredible work. So thank you again to all of you for joining us today for this really important conversation. We're very grateful to our panelists, Kent Yalowitz, Alan Kedem, and Mark Pinkert for sharing their insights into their litigation strategy, legal questions, and the broader impacts of Fuld versus PLO. And we really feel this case reaffirms the power of the law to deliver justice to victims of terrorism and reinforces the importance of preserving access to the American courts. We're also especially grateful to Arthur, not only for co-moderating, but for his outstanding leadership of AAJLJ's amicus committee. He's really brought his work to the forefront and has elevated the AAJLJ, and he's very humble. As a follow-up, we will be circulating a recording of today's program and a copy of the amicus brief authored by Mark that AAJLJ signed on to, a link to the Supreme Court's decision, and any other accompanying materials that might explore the case and its implications further. So if you'd like to stay connected, get more involved in AAJLJ's work, and of course, become a member, please, you can visit us at aajlj.org. We'd love to have you engaged in our mission. Thank you again for being here, and we hope you found today's discussion meaningful. We look forward to seeing you all at future events. Thank you all, and have a great day.
Thank you.
Thank you all. It was great.
Thank you for organizing this, Alyssa and Arthur.
Bye, everybody.
And Arthur, thank you so much.